Good evening, everybody. My name is Attorney Chris DeBerry. Welcome to another edition of my legal presentation, weekly legal presentation, Legalese, where I discuss legal topics that are relevant to personal injury law and my practice, and try to introduce people to ideas and things that they should know, particularly if they're ever involved in an accident or somebody that they care about finds himself in that situation. If you like what you hear in the presentation, please feel free to share it, comment, or like it below. And certainly, please provide me with any feedback you think may be necessary, any suggestions. And I certainly appreciate when you come up with questions. In fact, oftentimes they serve as a basis for the presentation itself. And that's helpful because I don't have to go digging for ideas. You guys provide them. And I'm happy to take the suggestions and run with them and try to give a good presentation to address them. Last presentation, I talked about the pre-litigation process, which is the process that begins when an accident occurs and generally ends once we file a lawsuit. But the pre-litigation process, and it's an important process, and much gets done, cases get settled, and it's very, very important that it be handled correctly. There is life beyond that process in situations where a case cannot settle on pre-suit demand or after negotiating to attempt the settlement. Sometimes the client's expectations may be too high, the insurance company may be valuing it too low, and you find yourself filing the lawsuit and going into litigation, conducting discovery, depositions, interrogatories, all that stuff, and working toward presenting a case to a jury. However, it isn't as simple as that, particularly in the state of Florida. Now, Florida is very, very big on alternative dispute resolution, or ADR. Now, alternative dispute resolution basically means any settling of disputes outside of the courtroom. So an alternative dispute resolution process is any structured process with a neutral, impartial person that assists the parties in reaching a voluntary settlement of a dispute. And voluntary is really going to be the key. And the two main um, sources, or the two main modes of alternative dispute resolution that I'm going to discuss now, are mediation and arbitration. And you may have heard these words, you may have assigned meaning or had some experience with them, but I'm going to get into a little bit of detail about what they mean. Now, this isn't going to be an exhaustive discussion. This is really just a primer on alternative dispute resolution, and hopefully introduce you to some ideas and some concepts that could be helpful and things you may not know. First, we start with mediation. Now, in the state of Florida, mediation is required to be ordered in every civil lawsuit that's filed. So anytime I file a personal injury complaint and they answer the complaint and we litigate the case, before we can go to trial, we have to first mediate the case. We can set a trial date, but before we go to trial, we are required to mediate the case under the Florida Rules of Civil Procedure. And the courts do require that we do this and try to get together and try to peacefully settle the case. And there are numerous advantages to mediation as a way to resolve a case. One of the good things about it is the parties usually agree to the mediator. The suggestions are made from one side, the other side, and generally you have to agree. So it's good that both parties are fairly comfortable with who the person is who's going to mediate the case. Now, a mediator is usually an attorney, particularly one that's practiced in the particular area of law that the mediation is going to be concerning. But in the state of Florida, you do not have to be a lawyer to go through the 40-hour mediation training and get your mediator certificate. So I remember when I had my mediation training years ago, because I'm myself a certified circuit court mediator, I had a former mayor in our group who was going for his mediation certificate. So not always doesn't always have to be a lawyer, but oftentimes you'll find that it's a lawyer, and not just that, but one that has experience with dealing with personal injury cases, and usually one that's worked both sides of the aisle, the defense and the plaintiff side. So just a little bit of background on becoming a mediator. Like I indicated, you need to do the 40-hour basic mediation training. and you work under the direction of professional mediators. You take tons of continuing legal education, and you try to participate in usual professional organizations for mediators. They have seminars and things like that, and help you hone your craft in mediation. Now, I am a certified mediator, but I really don't mediate um, as a neutral party, as most of the time I am there representing clients at mediation as their plaintiff's counsel. So I don't really do a lot of that. My brother Tom DeBarry mediates full time, and he's quite good at it, actually. Not just because he's my brother, but because he's a good mediator. Um, now, mediators can become certified, like I said, whether they're attorneys or not, and they just simply have to satisfy the educational requirements and be certified by the Florida Supreme Court. But whether you're an attorney or non attorney mediator, you are certified by the Florida Supreme Court. Um, if you have to maintain your certification throughout your time as a mediator, and Chapter 44 of the Florida statutes lays out very specific guidelines and what the minimum requirements are and what needs to be done. Um, Now, oftentimes you can have a dispute that's not a typical civil lawsuit, but you may decide to involve a mediator in it anyway. And part of the things that are good about mediation are these, and we use the letter C to kind of stand for them. The first and probably most important thing about mediation is it is strictly confidential. So nothing that goes on during a mediation between the parties as they interact with the mediator, as they interact with each other, even if they say something nasty to each other, it usually doesn't happen because mediations tend to be less adversarial than trial. Trial tends to be more like combat. But it's a confidential process. Even the judge can't know what's been said in a mediation. If the mediation is successful, then the mediator creates the mediation agreement. Before we enter into a mediation session, we all agree to sign a confidentiality clause in the mediation agreement. But once a mediation is successfully completed, the parties settle the case, then the mediator writes his report to the court. Or if the mediation were to impasse, he would then write a report indicating that the mediation, although attempted, was not successful without stating the reasons why. But it is strictly confidential. The other C that I think is very important is that it is you have more control in a mediation context. Typically, the structure of mediation is the parties come together in the main room, and the mediator introduces them to the process of mediation. And we attorneys know it already, but our clients don't, so we're always very happy to have a mediator that's cogent on the subject and is willing to explain to the clients the ins, the outs, and the possible rewards and pitfalls. But a mediator is going to bring the parties together. The respective attorneys for each party will generally give an opening statement where they explain what they feel the evidence in the case would show to a jury if the case were to be tried before a jury. And plaintiffs give their opening statement. The defense gives its opening statement. Plaintiff may have a rebuttal, maybe not. I've had rebuttal probably as often as I haven't, so as a plaintiff's lawyer. But once the opening statements are made, the parties then divide and split up into other rooms. So you'll have the plaintiffs in their room, you'll have the defendants in their room. And in fact, if you have multiple plaintiffs, multiple parties will probably have their own rooms unless they agree to be together. But usually that doesn't happen. So, and what happens is the mediator then serves as a facilitator between the parties to see if they cannot get the case to a posture where they can settle it. And oftentimes it's successful, and that's what makes it a good process. They say of mediation that a successful mediation is one where the defense paid more than it wanted to, and the plaintiff accepted less than it wanted to. So you get the idea that this is a compromise. So that's your other C. You have your control, you have compromise, you have confidentiality. And also what's very, very important is the whole control aspect, where the only decision makers in the room are going to be the plaintiff, usually my clients, and the insurance adjuster. And the insurance adjuster is one of the people that usually shows live or via some audio or video means. But they're the two people who make decisions, or as W would say, deciders. They're the deciders in the case, and they decide how much to offer and whether or not to accept that. Obviously, hopefully that's an educated decision, and if I'm doing my job, it usually is. So that's really the process of mediation. And why is it important, and why is it a good process? Well, for the reasons I said. And also, and I think control is really the thing. You have the ability to determine your destiny in a mediation. And it's very different once you've gone through a trial and you hand the case over to 6 jurors, all the evidence and all the testimony, and the judge reads the jury instructions to them like one time, and then they go back there, and 6 people whose only qualification in life is that they have a driver's license are then going to decide your fate. When you appreciate that dynamic, it's easy to see why mediation is a good process. That's why I became a mediator. But apart from mediation, there also is another process that I'm going to get into a little bit, and that is called arbitration. And arbitration is a little bit different than a mediation. You may have seen, if you entered into an agreement, that many agreements have arbitration clauses in them. So suppose you enter into a contract with somebody and it has an arbitration clause. That means that that party, for some reason, doesn't want to have a jury trial in case there's a dispute. They want to avoid it so much that they've built avoidance into the contract itself, so that you must then arbitrate the case rather than have a trial on a dispute. And the arbitrators are generally impartial. They're also chosen by the parties, whether it's an arbitrator or a panel of arbitrators. So once again, the parties should be fairly comfortable because they participate in the process of choosing the arbitrator. Now, there are arbitrations that are binding arbitrations, that are non-binding arbitrations, and each are addressed separately under the Florida Rules of Civil Procedure. I'm really not going to get into a lot of that. But the Rules of Procedure cover a variety of topics, including the court's authority to refer a case for arbitration, the appointment and the disqualification of arbitrators, the procedure for conducting the arbitration hearing, and the methods of enforcing agreements that are reached in an arbitration. Now, the rules basically invest the trial judge with the discretion to order civil arbitration if he or she feels it would be in the best interest, or it would be a benefit to the litigants in the case. And a lot of the time, a judge may order arbitration when the plaintiff's attorney may not be too crazy about it. They really would rather have a jury trial and not have to go through the arbitration process. An arbitration panel acts a little more in the place of the court than a mediator does. A mediator is just really there to facilitate bringing people together in the hope of being impartial and achieving a settlement, whereas an arbitrator is going to render a decision, or a panel of arbitrators, and that decision may be binding or unbinding. And arbitration itself is actually structured sort of like a mini trial. Both sides will make opening statements, probably in more detail than they would in a mediation. They'll go through the relevant facts, discuss the issues of the case, and present evidence, which may also include testimony under oath in front of the arbitrator or arbitrators. And both parties are allowed to examine and cross-examine witnesses and provide testimony under oath. Now, the arbitrator may not decide on the day arbitration is complete the decision. However, arbitrations are required to be completed within 30 days of the first arbitration hearing. And if a decision is made, it has to be rendered to the parties no more than 10 days after the decision is made by the arbitrators. And if a party has an objection to the award that an arbitrator wants to give, if the plaintiff wants to object, they have to be careful, because if you were to go to trial, if you demand a jury trial after arbitration, and the jury were to render a judgment in that case, and by judgment I mean whatever verdict the jury renders minus whatever offsets apply and which are deducted by the judge after the verdict is rendered, then becomes the judgment. If that judgment is less than the amount that they are attempting to than the amount that was actually decided in arbitration, then plaintiff's counsel, or the plaintiff themselves, not his lawyer, but the plaintiff himself, will then owe defense counsel their attorney's fees. So you can see why You have to be very, very careful about arbitration, entering into it voluntarily, and being careful if it's one where it's involuntary. There are certain cases actually that cannot be arbitrated. Apparently, bond estrictures is one of them, and this is in Rule 1.800 of the Rules of Court. Habeas corpus and other extraordinary writs are not subject to being arbitrated. Bond validations, civil or criminal contempt proceedings cannot be arbitrated, and any other matter that may be excluded by the local rules of the court prohibiting arbitration in those particular matters. So that's really all I wanted to discuss tonight, just to give you a familiarity with what options are available other than having to take a case to trial necessarily. And mediation or arbitration are great processes. The professionals that conduct these are generally a very, very educated, very experienced people, and you can feel comfortable in their hands. I have been to very few mediations in my career that I didn't feel had some merit to them. It's very, very rare that I would ever walk out of a mediation thinking that the attempt at settlement or the settlement wasn't a good process. But nobody's perfect. But anyway, folks, I want to thank you very much for your time this evening, and thank you for tuning in. And please, like I said, feel free to share this information, like it, comment on it, make suggestions, or give me more questions to answer. And once again, thank you very much, folks. Have a good evening and be safe.